Now, the case of recaptured fugitive Thabo Bester and his co-accused continues to dominate the courts. Bester's partner in crime, Dr. Nandipha Magudumana's she's questioning her arrest and deportation, declaring it unlawful, and her urgent application will be heard today. And our senior reporter, Silindelo Masikane, is there to keep an eye on proceedings. Sli, thank you so much for joining us. Of course, much anticipated developments that we are following up there in the Bloemfontein's Magistrates Court.
Certainly so. We are expecting the urgent court application filed by Dr. Nandipha Magudumana's lawyers last week to be heard here in the Free State High Court just after 10 a.m. this morning. Of course, we have all seen her court papers and what she's alleging in terms of how her deportation, or what she calls an extradition, transpired in Tanzania. She claims she was blindfolded. She claims that officers from the South African Police Services told her that she was going home and transported her to an airport where she then boarded a chartered airplane back to South Africa. Now, we also know, of course, that in the Magistrates Court, where legal proceedings against her, where she's accused of aiding and abetting Facebook rapist Thabo Bester, she has reserved her right in the Magistrates Court to apply for bail. Her reasons coming from her lawyers saying that there was crucial new evidence that they needed to look into before she can apply for bail, and then subsequent to that, they of course then headed to the High Court to file these court papers on an urgent basis. Now, to just unpack what we can expect in terms of the proceedings this morning, I am joined by legal expert Mr. Riaz Hanbury, who of course specializes in immigration and deportation. Thank you so much for your time, sir. Maybe let's talk about urgency before we get to the merits of this particular application. Do you foresee the High Court seeing this particular matter as being urgent?
Morning, thank you very much for having me. Indeed, I do see it as being urgent because you're dealing with the question of the liberty and freedom of an individual, and inherently so in our court system, when that question is raised, the matter would be inherently urgent. So I would think that the court would accept her application as being an urgent one. Yes, definitely.
Then let's talk about the merits. So she perhaps does go past that hurdle of urgency, and now the court will hear her matter in terms of the merits of her case. You've read through her papers. There's not much that we know about what transpired with her arrest, but in her papers she is claiming an extradition, whereas the state insists she was deported.
Indeed so. The application is quite an interesting one. As you go through the application, it will be noted that the applicant does mention very briefly about deportation, but also focuses more on extradition. If the matter is a matter of extradition, my view is that firstly the Minister of Justice should have also been cited in this matter, because the laws surrounding extradition and the treaty that has been signed by South Africa and Tanzania clearly indicates that the Minister of Justice is supposed to have launched an application and a request for her to be extradited. However, the application seems to be also a little vague in terms of supporting evidence in her application to say which way it should actually go. So it will be quite interesting at the end of this application and processes in court to hear what the outcome would be.
Do you find it also a bit peculiar that the Home Affairs Department in particular is in essence demanding now to be respondents in this application, saying that they find it sinister that in fact they were not cited as respondents or even asked to come and state their case, because according to the department, they sent immigration officials to be the ones to take Magudumana from Tanzania back to South Africa?
Yes, it is absolutely interesting that the Department of Home Affairs or the Minister of Home Affairs is not cited in this application. It's quite clear from his media briefing recently that due process was followed and she was actually deported back in terms of what Dr. Arun Mutsoaledi has placed on record in his interview. So I do find that interesting, and the application itself, as I stated earlier, is an interesting one. My view also is that if, for example, Dr. Magudumana is successful in this application by some chance, the National Prosecuting Authority has the sole discretion on who to prosecute. So my view is that even if she is successful, the chances are high that if she walks out of court as a free person, she can be rearrested, because the National Prosecuting Authority has the discretion to reinstitute proceedings. Remember that her whole problem with the process thus far, including requesting this court to set aside the current proceedings in the district court for the charges that she is facing, is quite strange in my view, in this sense that she is alleging that she's illegally in court because the alleged abduction and process that was or was not followed renders the whole process that follows after to be illegal. And the National Prosecuting Authority is the only authority in the country that decides who to prosecute, when to prosecute. So if she walks out successful in this application, they have all the rights to reinstitute proceedings, and she's currently now in the country. So she can be rearrested and brought back to court.
That was actually going to lead me to my next question. Does the High Court actually have the jurisdiction to set aside legal proceedings that she's facing in the Magistrates Court?
Look, it's an interesting question. If it is found by the court that due process was not followed, because there's a bit of haze around that. And if it is found, they can set aside proceedings. However, what will happen is, the likelihood is that the National Prosecuting Authority will reinstitute proceedings against her, and that's my view.
Do you think she'll be successful?
I don't think she'll be successful in the application because she has a long road to walk. Like I mentioned earlier, I feel the application is a bit vague, especially regarding the point that she raises about abduction. Remember that up from the point of first appearance through up until her application was launched at the High Court, abduction was never something mentioned. She had the opportunity to raise this at her first appearance in court. She didn't. She did not raise it even at the second appearance in court, where she eventually placed on record that she's abandoning her right to bail application. I'm also of the view that the question of abduction could have been a point raised during the bail application, and the district court would have been in a position to make a finding or a ruling on it in any event.
Thank you so much.
Pleasure.
All right, that is legal expert Mr. Riaz Hanwari, just unpacking what we can expect after 10 a.m. this morning. I will be bringing you more analysis as we build up to her appearance. We're not too certain whether or not she will actually be appearing physically, but of course we will be bringing you those visuals live here on ENCA DSTV channel 403.